Hello and welcome to the special episode of Simply inTAXicating. Today we are going to talk about the growing mountain of transfer pricing disputes in India. Transfer pricing, the new kid on the taxation block, has apparently earned loads of disrepute for the Indian tax administration. Well, this is likely to be overhauled with the Union Cabinet taking a decision not to file an appeal against the Bombay High Court judgment in case of Vodafone. To demystify the various aspects of TP issues, and first let us hear out Mr. Pradeep Dinodia how exactly the Vodafone decision of the Union Cabinet has been interpreted by the transfer pricing practitioners community in India.
I think a very good and a positive decision has been taken. And in fact, if you look at the government, what is the government? It is also comprised of the people, by the people, for the people. And tax is also an instrument of the people, by the people, for the people. So why should not a positive decision be taken by the cabinet? I think it's a statement of intent by the government. The new government, which has come into force in May of 2014, is showing an intent. They have been saying that we will take a non-adversarial approach to tax matters. They have been saying in press interviews. But it is a statement of intent, and this has come out very strongly by a cabinet decision. I mean, there can be no better authority or higher authority in India than a cabinet decision of the government.
Correct.
So I think there's a statement of intent that they mean business and they want to make India as a hub for manufacturing, which has got ease of doing business, which does not have unnecessary litigation in fields which are not really which actually do not result in neither goodwill nor tax.
So we have heard Mr. Dinodia. Now the issue is, we have a large transfer pricing practitioners community in India, whether they also subscribe to his views. There are more takers. Let us go to Mr. Sanjeev Malhotra, partner BMR, and let's see how he interprets the cabinet decision on Vodafone.
The government's move to step in, to clarify what their intent is, and to put a stop to a litigation which would have ordinarily gone to the Supreme Court, I think is a quite a bold and a good move, because it brings in a lot of positivity, where the government is making a statement to say, all right, where we feel taxpayers are correct or the position taken by the revenue is not fair, we won't wait for things to crawl all the way for the federal court and hope that ultimately the taxpayer will win. We'll step in to correct where things are not going right. If the intent of the cabinet is that every now and then, as and when there is a high profile case that comes in, they will step in, which first I don't think so is the intent. I hope it's not. But if they start doing that, surely that's not the right way, may not be the right way, because what you're doing there is you're undermining the powers that the income tax officer has or the board has, right? You have these institutions with an intent that they're going to implement what the law is.
So we have heard two noted transfer pricing experts in India. It is also very clear that the Modi government is not going to allow avoidable transfer pricing litigation in days to come. We have in the studio Mr. TP Sengupta, consulting editor, taxindiainternational.com, and also former Joint Secretary, Foreign Taxation Division in the Central Board of Direct Taxes. Sir, please tell us why there is so much of disputes in transfer pricing.
Multinationals by definition operate in multiple jurisdictions. If the rules relating to the computation of tax and the tax rate in all these jurisdictions were the same, there would not have been any transfer pricing. But such is not the case, and the difference in the regime of taxation and tax rates in different jurisdictions is what is exploited by multinationals, and that gives rise to transfer pricing. Now, we must realize that this is a serious problem because almost 60% of the world trade is covered by multinationals. And the multinationals trade within its own entities, the subsidiaries and branches that operate in different jurisdictions, and they propose these transfer prices that are set in transactions relating between associated enterprises. These are not determined by market. So, that creates problems for tax authorities all over the world, not only in India.
As you know, the black money and the tax havens are the hottest issues in India today. So, is there some kind of nexus between transfer pricing and tax havens?
There are a few factors which accentuate the problems. The first one is the concept of separate corporate existence. Companies' existence cannot be very easily denied. The second is the existence of tax havens, even if they have got very little substance. And the third point is, of course, the fact that there is complete lack of transparency and lack of exchange of information from these tax havens. So, these three factors actually exacerbate the problem of transfer pricing that the tax authorities face all over the world.
So, sir, the transfer pricing disputes are not very peculiar to India. It is common all over the world. Let us go to Mr. Dinodia to know a little more about the global scenario of transfer pricing disputes.
World over, transfer pricing accounts for almost 70% of all tax litigation in the world, and there are actually only 10 or 12 issues which are deeply litigated and highly contentious. And if any country can find answers to those 12 issues, this litigation will completely peter out over a period of time.
So, all transfer pricing disputes largely originate from a bundle of about 10 to 12 issues at the global level. In case of India, there are issues like AMP, cost contribution, selection of methods for determining arm's length price, etc., etc. Keeping in mind all these issues, sir, coming back to you, please explain the principles governing the arm's length standard at the global level.
Obviously, there is much of the problem in today's world relating to transfer pricing legislation is in fact relating to the efficacy of the arm's length standard itself. No two companies can be considered to be can be found who are exactly same in all respects. So, either the absence of comparables or the dispute may be relating to the adjustments. Ultimately, the dispute is about finding the right comparables or for making appropriate adjustments to make them comparable, make the companies comparable. But to answer your second question, whether this is a problem peculiar to India, it is not. You are aware that there is a base erosion and profit shifting project. Out of those 15 action points, 3 relate to transfer pricing alone. One of them, in fact, dispute resolution is in addition to the 3 issues, but then the dispute resolution is action point 14 of the OECD BEPS project. There also, if you see the discussion paper that has come into the public domain recently, that talks about dispute resolution mostly relating to transfer pricing disputes. So, this is an issue which is receiving the attention of
global experts
of experts from all over the world, including in India.
Right.
So it is not as if these transfer pricing disputes are peculiar to India.
Right.
The only problem, the only issue that arises here is that in other places we do not hear so much of the transfer pricing disputes. That does not mean that the disputes don't exist.
Right.
What happens is that in India there are too many forums available for parties to pursue their disputes.
Right.
Normally, in the absence of comparables, the MNCs, particularly from USA, they prefer to settle their disputes through the competent authority process.
Right.
So, since the competent authority process is a confidential process.
Right. So there is no
So,
transparency. There is nothing in public domain.
Nothing in public domain as to what is the nature of the dispute, what are the issues involved,
Right, sir. Okay.
as compared to in the case in India, where the appellate processes, after all, we will have to state the case, you have to say what are the issues involved,
Correct.
what are the arguments involved. So there is a transparent process.
So, sir, you are saying that since it is a government to government process, either under the MAP or AP bilateral, where what cooks inside is generally not available in the public domain, therefore all such alternative instruments to settle disputes may not have any precedence value in this In this scenario, is there a need for a global forum like the WTO for settling TP disputes on international level?
Yeah, ideally, if considering the disputes and the amounts involved in these disputes, it would be definitely in the interest of everybody to try and have some kind of an organization, an international organization, but such an organization must be something in which everybody has faith, both the developed countries and the developing countries. It is very necessary for the developing countries to have faith in an organization so that they can submit to their jurisdiction, because after all, taxation is the sovereign right of countries, and the sovereignty issue is very sensitive. Is a very sensitive issue for most of the developing countries, including India.
Right, sir. So, before we wrap up this program today, let's once again go back to Mr. Sanjeev Malhotra and find out whether the Indian TP administration is actually functioning properly or not.
Okay, so I may be biased because generally I am sitting on the other side of the table, so I would generally not be happy with what they are doing, but I think they are doing their job. We are doing ours. To be fair, one needs to understand the constraints under which the officers also work. In most of the cases, the past years are in litigation. So for an officer to come in, practically speaking, and take positions which are contrary is difficult. The government believe or the revenue department believe are the right way of looking at things. We may believe they may not be right. So there's a difference of view, and that's what the courts are for, to settle it. One pain point that generally my clients and we as their consultants face is that the level of aggression at times is high. But I would not want to paint all officers with the same brush. Many officers are very nice, they are very accommodating. And as I said, they may have their point of view, we have our point of view. It doesn't make them any right or them any wrong, right?
So, going by the observations of Mr. Malhotra, there is nothing terribly amiss about the Indian transfer pricing administration. They are simply doing their work properly and as per the law. They have also conducted about 20,000 transfer pricing audits and made adjustment to the tune of more than 2 lakh crore. Anyway, the key takeaways from this program are: A, the cabinet decision to step in was not to create a precedent but only to express the intent of the government for the global investors. B. The TP disputes involving MNCs are going to come down over the years because of the introduction of alternative instruments like APA, safe harbor rules, and also MAP. C. The arm's length standards, which have obviously some inherent flaws and drawbacks, it will always continue to throw challenges for selection of appropriate comparables for all the taxpayers. And D, the Indian policymakers, if they take the initiatives and list out all the contentious issues and come up with innovative legislative and procedural tools, a good chunk of TP disputes can be settled down. Thanking you all for watching us. You can send your feedback and comments, editor@TIOL.in, and also subscribe to our channel on YouTube for keeping yourself updated.